Thanks everyone for coming and braving the, I guess it's freezing, slushy rain. So today we're here for open patent licensing for both fun and profit. So I thought I'd kick things off with a short interpretive dance by the panel, but no, we're not going to do that. Instead, I think before I start, I thought it'd be useful if each of us could just introduce ourselves, just so you know where we're coming from. So I'm Mike Kasdan. I'm a partner at Wiggin and Dana. I've been doing intellectual property law, focusing on licensing litigation for my whole career, mostly as outside counsel, but I spent a couple years living in Japan, working at Panasonic, which gave me kind of the in-house perspective on this whole licensing game. So, yeah.
Sure. I'm Kevin Prey. I work for SAP. I'm in our IP strategy group. I do a lot of pre-litigation, licensing, and policy kind of work for SAP. I'm here tonight primarily, I guess, to talk about the lot agreement, which we'll talk about, but it's one of the, it's an initiative that was started that SAP is a founding member of. And we'll talk more about it tonight.
I'm Brian Chase. I'm general counsel at Foursquare. I'm here to talk about what it's like to be sued by patent trolls, which unfortunately happens a lot. But back in the day, I was a refugee from patent law. I started as a patent attorney. I left when I was involved in a litigation where we defended the patent holder of a patent that covered shipping products, the claims comprising creating a box, putting something in the box, closing the box, sealing the box with adhesive, and then shipping the box via certified carrier, which allegedly somehow was a patent. I subsequently left that, but obviously, it's the area right now is very, I would say, hostile to startups, and so very interested in any type of mechanism that we can find to address that.
I'm Andrea Casillas. I'm with the Open Invention Network and the director of Linux Defenders. These are really cool stories so far. I'm here kind of bringing a skew from the, I know, just from an open source perspective. We generally work with a lot of corporations and companies that have patents, but we also rely and partner with a lot of open source projects, companies, developers, etc. So that's where I'm coming from on this.
I'm Jason Schultz. This is my very first official NY Legal Hackers event, and I'm really excited because I've actually thought of myself in a lot of ways as always trying to hack the law. I worked for a nonprofit called the Electronic Frontier Foundation for many years before going into academia, where I now hopefully train law students to think like EFF, ACLU lawyers and try to assert civil liberties in the digital space, as well as tweak the IP system as much as we can to promote open innovation, interoperability, access to knowledge, competition, all the good stuff. And so I'm particularly excited because before I went to EFF, I actually spent 4 years litigating patents at a private firm and never thought that things would connect. And then when I got to EFF, we started to think about what can we do about patent problems. And so this whole conversation here, I think is a really good moment in time, because I think the traditional concerns of civil liberties and public interest groups have really aligned with a lot of the concerns of startups and tech companies about what's going on with patents and what should we do about them. So I'm excited to talk to all of you tonight and panel.
Okay, thanks everyone. So I'm just going to speak for a few moments just to try and frame this issue. I think, as we've already seen, we're going to get a lot of different perspectives on it. But I guess the main question where I want to start is, why are we here talking about licensing models and these defensive licensing or sort of open patent models in particular? Why is that interesting? Why is that important? And I think I'll start by saying that I think in recent years, and it's not just because we're up here a bunch of patent people, patents have become more mainstream. You read about big patent-focused thing. Apple, Samsung is in the news. There's a lot of news about patent trolls or licensing entities. There's a lot of action right now in Congress in terms of patent reform. And I think just to frame that, I wanted to talk about licensing over time a little bit. Because I think when you come into, why would you license a technology? I think there are kind of two flavors. There are probably more, but just start with the two. The first is, you need access to a technology, right? You need to commercialize a product. Someone's invented this great thing, and you want a building block. And so, licensing is important just in terms of, building out an information economy. But licensing doesn't always happen in that way of people seeking building blocks. If you're in a company, as Brian will tell you, as I'll tell you from my time at Panasonic, the way that licensing often happens is there's a threat of litigation or enforcement, right? You get a nice letter or a not so nice letter from another company or a company that's been set up to license patents, and they send you, claim charts and assertion, and sometimes it's a ridiculous patent, and sometimes they're real patents they have to study, and they say, you might be interested in a license, and what that really means is you want to engage in licensing discussions and ultimately, come to a license so you're not involved in litigation, and sometimes when you can't, it ends up in litigation, which is costly and protracted. And I think the history of licensing is kind of interesting. I think if you look back to the 1970s and big companies recognizing that you can make a lot of money not just by making products, but you can make a lot of money by licensing your patents. You have companies like Texas Instruments and like IBM had very successful big licensing campaigns, signing multi-million-dollar agreements and going to people and getting them to pay them money and tax. And I think what happens over time, this will be a very abbreviated history because we want to keep it short and have time for drinking afterwards, is mechanisms evolve to make this process more efficient, right? So you look at things like patent pools, right? Heard of maybe MPEG or standardized technologies. It's very expensive to go around and pay every person who may have a patent, and a lot of transaction costs involved in doing that to get those rights. So over time it's recognized that aggregating these rights and having a clearinghouse to get these in a one-stop shop is valuable. And what happened more recently is and it's not so much a recent phenomenon, patent trolls. In some ways it's been around forever, right? In some ways the Wright brothers were kind of a licensing entity. They actually weren't very successful in making great airplanes. That was made by a guy named Curtis, who they essentially put out of business because they sued him for patent infringement. But they had a great patent, or at least a patent that was broadly enough construed that they could make a lot of hay with it. But so this licensing game has been around a long time, but you hear the term patent trolls, and depending on where you sit, and I think depending on the quality of the patent and how far you're stretching it, you're either calling them a patent troll or you call them a licensing entity, right? And either you see it as kind of a tax or a shakedown, or you see it as an ultra-efficient licensing mechanism. But those are two sides of the same coin. But there's been the rise of these non-practicing entities, and particularly in industries like consumer electronics and software, where you need a lot of different patent rights to make a product, getting involved in litigations has been very, very costly. And it's interesting, there's been reaction. There's been reaction by the industry. Certain big companies have set up licensing entities and said, so a company like British Telecom says, well, it's more efficient if I have a patent holding company, and they can just sue people for patent infringement, and I can go make products. And you also see the rise of folks that are aggregating patents for defensive purposes, just so people aren't asserting them. So the world is very complicated. You have big green circles and big red circles and lots of lines, but what you really have, you have operating companies that are entering into licensing transactions. You have non-practicing entities, which could be individual inventors, they can be universities, licensing entities like trolls. And what you really get at the end is the problem is you get very costly and protracted patent infringement litigation. You may be paying a lot of licensing as royalties. You have very high transaction costs being involved in this. And we have this great system for incenting innovation, right, in our Constitution, but a lot of people say this whole problem is just a tax. I just want to go out there and make product and innovate and be an entrepreneur, and this is just dragging me down. So there have been efforts in Congress, right? They're saying, well, we got to fix this. I was at a panel yesterday that Jason moderated. There were a lot of smart people there. I was only there for about half of it, but it seemed like they weren't close to fixing it. And so what's happening now, and this is what we're here to talk about, is the industry is saying, well, what can we do about it? How can we be creative and innovate and sort of solve this patent problem And there have been some different efforts, and we're going to talk about a variety of them tonight. So one effort is efforts like creative, open patent or patent commons approaches to try and carve out kind of a safe haven where everyone can innovate and everyone's cross-licensed and people are sort of happy and protected. And I think there are a lot of companies that are innovating and thinking about this. Like you've probably read about, Tesla and Elon Musk has laid open a bunch of patents. Playing with the idea of, is this a better way to incent innovation? You look at what Google is doing with its Android ecosystem. Like in agreements, Google's trying to say, look, if you're going to play in Android, I don't want the people playing Android to be suing each other. So you're going to say you're not going to sue people, other Android users. So what we have tonight is we have a variety of techniques that have been developed and are being played with, and we're going to talk about them. And I guess, and those are the defensive patent license. It's one thing we'll talk about. Jason will talk about that. Twitter has an agreement that they designed to address this issue. We'll talk about that way. Kevin said he's going to talk about LOT, which stands for license on transfer. It's like a bit of a poison pill concept. That sounds bad, but it's good. It's a bit of it's a creative licensing mechanism.
It's only poison for trolls.
It's only poison for the bad guys. And also the Open Invention Network. And I know a lot of folks here are startups and entrepreneurs, and I think that it's interesting, and we'll talk about different approaches when your company is of one side and what factors play into how you treat patents and what types of arrangements are going to be beneficial as you become a more mature company. So I think at this point, I'll turn it over to maybe Jason kick us. Actually, Brian maybe kick us off with the startup type perspective.
Yeah. So, how many people here are from startups, or are considering creating a startup, or like representing startups? I don't know. Okay. So, the one thing that's interesting about startups is that startups have engineers. Engineers do not like patents. Engineers go through college hearing all these bad things about patents. There used to be, when I started out in law, it seemed like the cool thing for engineers was to get their name on a patent. It seems now, at least at Foursquare, engineers, the worst thing I could ever ask them to do is have their name on a patent, because then they're part of the problem. On the flip side, you have investors who want value in the company. They know that you're coming up with really cool ideas. They know that you're innovating, inventing, and they want some sort of asset associated with that. They're worried that they're worried that the people who are working your company will go to another company and create something similar, not stealing trade secrets, and so they'll push in the other direction. So the question is, what do you do? Twitter, for example, when Twitter went public, it only had 8 patents. It only held 8 patents.
And the investors were not happy about that.
And investors were not happy about that. After they went public, they went and acquired a lot more patents. Facebook, on the other hand, bought a huge portfolio right before it went public. But again, these weren't in-house bred patents. These were, hey, we'll go and buy them from other people, and so it looks a little bit better. So there is this fight in between. And so when I work with our team, I have to balance those two. I have to balance the investors want this, it can be good for the company. On the flip side, us as a company who, in the 5 years we've been around, we've been sued 6 times by patent trolls. It's a very costly thing. We don't want to be the future patent providers to these entities. So coming up with a way to address that is important. And I've been involved with the DPL. I've been very involved. I gave comments to Ben Lee at Twitter on their approach on what can we do. I don't think we've got a perfect approach yet, but I think it's better to be thinking how can we address this issue while still giving people protection, still giving value to the patents without incentivizing a market where it's just attack and not actually innovate.
Okay, thanks. Maybe Kevin, as our resident larger company representative, could just share a little bit of the perspective.
Yeah, I mean, obviously, SAP, we're a large company. We have thousands of patents. I think the last check, we have something like 10,000 worldwide. And so we have a large department that is focused on procuring patents, prosecuting those patents. We also, at the same time, are defendants in patent litigations. We get sued by trolls, we get sued by failed entities, things of that nature, and we've dealt with them as best we can, and we think there's definitely room for improvement in our system here. I personally at SAP have been working a lot on some of these alternative sort of mechanisms to try and create more a level playing field and try and improve the quality of both the judicial system, judicial decisions, as well as the system, how you get there. And so I guess that's kind of what brought me here to this panel is to talk about the lot, which is an initiative to try and sort of starve off the patents, the supply of patents to the patent trolls, and really bring the level playing field back to where, look, if you have a dispute with a company about their use of something you view as your patent, and you have a patent on, that's fine. You can go ahead and have that dispute, but it's going to be between two operating companies who both have, if you will, skin in the game and can go about it in a way that doesn't have tremendous asymmetries in terms of cost of enforcement and things of that nature.
Yeah. And just to be clear, I mean, I said before that non-practicing entities are more efficient licensing mechanisms. Kevin talked about battles between operating companies, and that's because if you're an operating company and you're in a litigation or in an assertion with another operating company, you both have patents, you both have products, you both have exposure, you both have a risk, right? And that can lead to somewhat of a détente type situation. What shifts is when one company doesn't make any products and they're just out there asserting patents, that sort of balance goes away. So I think the way we want to structure this is we want to talk about some of these cutting edge approaches, and each of these guys is going to talk about one of them. Some have slides, some will just speak, and then I think after that we'll just have kind of a discussion. I'll talk a little bit about just where we're at, where we see the future going, how this impacts different types of companies, and then we can take questions. So I think just to kick it off, maybe Jason could talk about DPL. DPL draws on concepts that came from copyright law to see if you can apply a sort of copyleft or commons type approach to this patent problem.
So I can talk about the DPL, and I'm also going to talk a little bit about this Twitter agreement. But the kind of framework I want to sort of suggest that you think about this in is you're all going to create cool shit, right? It's going to happen at some moment. It could be cool shit that does something cool and interesting and blows people's minds. It also could just be fixing a problem, right? Something that has bugged you forever or bugged someone else forever. Or it's been figuring out how someone else could do something really interesting. And all of this stuff, which I'm going to talk about in a second, is potentially patentable, right? And you think about this like, wow, well, if this is true, why aren't people patenting every day, every moment of every second, right? Because we're doing interesting stuff all the time. Well, there are reasons for this, right? So some companies do, in fact, do that all the time. They try and patent every single little incremental or more than incremental thing. Sometimes they get the patent, sometimes they don't. But patents, unlike copyright, we'll talk about in a second, patents actually cost a lot more money. Like you have to file them in the patent office, you have to usually pay your attorney to do a bunch of stuff. Copyright, for those of you who don't know, is actually free. You just like write something down and boom, like this slide, I have a copyright on this slide.
Congratulations.
Yay, woo!
Really
And
lovely.
you all owe me no. So, I mean, copyright's a lot simpler, right? And I'm going to talk about why that matters in a second. But when you think about patents, especially as a startup or anybody who's working on any kind of project, even if it's as a volunteer, it kind of is a strategy that is implicit about thinking about, well, do I want to patent stuff or not? But often we just sort of avoid it. It's like we're in denial. We're in patent denial. Okay, we're all in patent denial. Generally, we don't want to think about it. We want to do other stuff. It's boring lawyer stuff or it's heinous stuff. And so what I'm going to talk about now is maybe flipping that around, right? So when you think about companies and you think about company identity and who you want to be in the world, right? If you're Google, you don't want to be evil or whatever. When you form your company identity and who you want to be, the pitch I'm making to you is thinking about what you want to do with patents is actually really important. Like knowing what you want to do. So if you think about open source software, this used to be a crazy idea, right? It used to be something that was considered insane by the industry that you would ever open up your source code and show anyone, let alone license it to sort of anybody who came along. You're insane, how are you going to make any money, right? And there's this thinking the same way about patents and like, oh, we can't show people what we're doing and like, oh, it's like, why would we open this stuff up? And we'll talk a bit about what that means later. But this idea that you could open stuff up and you could share it And that could be not only just a good idea, it could be maybe a way to invite people to help you out and collaborate with you, but it actually could be like part of your brand, right? Who you are in the world, what kind of company are you? And so now you see, as maybe a lot of you in the room are, folks who use open source as a signal to say, I am this kind of person. I write this kind of code. I want to work with these kind of people. This is the kind of company we want to be, right? So think about patents in the same way. Could we do something similar to patents and sort of signal, not perfectly, but hopefully close enough, I'm one of the good people or one of the bad people, maybe you don't say you're a bad person, but sort of signal what you want to do with things and how you want to be in the world as a way to kind of think about it, similar to what we do with open source software licensing. So, open source software licensing, what can we learn from it? So open source software licensing to date is primarily based on copyright law. I won't give you a lecture on copyright law. If you want one, we can talk about it later. But here is a representative chart from the Open Source Initiative of some of their affiliates, right? So these are the people that this particular nonprofit who works in open source licensing is kind of including as who's in their orbit. Like who are the nonprofits and the foundations and the companies and the entities who all kind of work with them on defining the legal part of open source, right? So you see there's a pretty big network, some pretty powerful players, small people, big people, all kinds of interesting people. What can we learn from this? Like, why is this model working, right? Well, one thing is, there's a ton of innovation going on, right? The reason that this model works in some ways is because we actually know that open source and open source philosophies and companies and projects produce a lot of innovation, right? So here's just one small little snippet that I threw in there, but if you look at just the Linux Foundation and just this one update, you see, wow, that's a lot of code. And it's actually, that's a lot of people, right? And the fact that they're doing this all in a kind of sort of loosely coordinated way is actually pretty impressive, right? So we know this model works for innovation. We know this is actually something that will produce interesting things, right? All right, so what would it look like if we did this for patents? So this is my pitch, right? I'm throwing in my thing into the ring, although I will tell you that I am fully supportive of all the options we're going to talk about tonight. When we talk about pros and cons, I'm in the positive on everything. So what if we had a license that was not so much for copyrights, but for patents that tried to do the same thing that open source licenses do? And I won't go into the nitty-gritty unless you want. We can do that later. But as many people might know, you can pick your open source license. So you can pick a GPL license, you can pick an MIT or Apache license, or BSD. If these things don't mean anything to you, just trust me, these are the licenses you can generally pick. And you just slap it on your code, you put, or up on GitHub, you designate it that way, and then people know where you stand, what they can do, what they can't do generally, right? Some fuzziness at the edges, but generally they know. So we tried to do the same thing with patents. We said, okay, let's come up with a standard license. GPL or Creative Commons, those of you familiar with Creative Commons for like more aesthetic entertainment media, it's going to be the standard thing, same time, everyone knows what it means. If we tweak it, we'll tell people what we're doing, but generally it's going to be static. And the idea is we make it royalty-free, you don't pay any money at all, it's perpetual, right, which means it lasts forever, you never have to worry about it fading away after a year or 10 years. It's irrevocable, which means no one can yank it back. And it's reciprocal, which means the deal is it commits everyone to being defensive, right? Which is this idea that I won't sue first, right? It's like, actually Eric wrote this great blog post that if you saw it about did Han shoot first, right? Well, you commit to not shooting first. You're sort of committing to be not Han, which is sad because that would be cool, but anyway, we're committing to not being Han. And the idea is everybody makes this commitment. So you start to create a network of commitments, much like with open source software, where if you look at the viral components of open source software, you put your source code out, anybody who modifies it makes the same commitment to release their code to anyone else who would modify it, who has to release their code, and so on and so on and so forth. This is a couple of things which we think are good. One, and I won't go into patent law 101 here, but if you want to geek out on patent law, we have a ton of experts on the panel here. The idea about patent law, though, to some degree is it's the first person who files at the patent office to invent something who gets the patent, as long as it wasn't obvious to get it. In other words, it wasn't a trivial little tinker or improvement, right? So getting to the patent office first is actually really important. There are other ways to kill patents, but the best way to kill anyone else getting a patent is to file first, right? Well, if patents are evil and people hate patents and people hate patent lawyers, we're not going to file very many patents in the open source community. If we turn that around and think of a way to do patents for good, to promote open innovation, maybe we can get there first and prevent a lot of proprietary patents from being filed. We get there first, we file, they file second, the patent office goes, these guys are first in line, open source wins. It also prevents future trolls from threatening people who are part of the DPL network. And this goes to the irrevocable perpetual part, right? So the idea is, if we all agree, we have, let's say each of us has 5 patents, we all agree to license each other at the same time, for free, forever, as long as we all stay defensive, and then I decide I'm going to sell my 5 patents to a troll. Well, you're all safe. You all have a forever license that can't be revoked. That troll basically won't go after you, they'll go after someone else, right? That's the idea. So let me run through just really quickly what this could look like, right? How big could this get? And this will be where I end on this, and I'll jump to the IPA in a second. So I did a quick case study. This is very loose math here. And I looked at Bugzilla, which is the bug database that Mozilla uses to track bugs on a lot of products. You can use it for your own products, but they do it with theirs. And I said, let's see, a patent. What is a patent? A patent is basically a problem that people have had that they finally come up with a solution, right? So, and they try and patent the solution to the problem. How many bugs have been filed since they started tracking them in '97 with Bugzilla? Almost 500,000. How many of them have been solved? Right? So, sorry to say, they've tracked a lot more, but how many of them have been fixed? How many of them have been solved? About 500,000 bugs, right? So, I thought about this in terms of Linus Torvalds' law about with enough eyeballs, all bugs are shallow, in other words, fixable, right? Maybe with enough eyeballs, all bugs are patentable, right? Not all of them, but a big, huge number of them. So, 500,000 bugs fixed in 17 years, 100,000 roughly in the last year alone. What if only 10% of those were patentable? How big of a patent portfolio would Mozilla have right now, assuming everyone assigned it to Mozilla as the kind of steward of the project? 50,000 patents, 10,000 in the last year alone. Now, of course, there are details of getting the patents and prosecuting them and getting the patent office to give them to you and the fees and all that. We can talk about that later. That's a 10% mark. Turns out that if you calculate and weight the average, the patent office actually ends up granting about 93% of all patent applications. That number is probably a lot larger. So think about that. Here are another couple of quick case studies. I don't know if you know Code for America, public-minded open source projects, right? 38 apps, 18 scaled apps in the last year alone. What if they patented all that? GitHub, a lot of open source projects on GitHub. Open source hardware is becoming a big deal. I'm wondering how are we going to work out what we're doing with IP. Copyright is not enough, by the way. Let me just tell you, it's a whole other conversation. The copyright's not going to help open hardware. It's going to have to be patents or something else. 3D printing, Kickstarter. One of my favorite clients, I will say they're a client of mine, NYPL Lab, making lots of cool shit. Tesla, which was mentioned earlier, thinking about open patents. What if we built an open patent network? Anyway, so this is the idea. Basically, I'll stop there with the DPL. We can talk about it more later. Let me talk about the Twitter IPA just for 2 seconds.
Why don't you talk about the Twitter IPA now?
Yeah. It won't be as long, trust me. That was my pitch, Tom. So what did Twitter do? Basically, Twitter did something, and by the way, you know, they're really great lawyers there, and they're thinking about this, and they're sort of thinking about it, I think, in parallel with a lot of these different conversations. What they said is, we just want to do this for Twitter. In some ways, it's kind of a labor market advantage. In other words, if you come work at Twitter, it's cooler than other companies, I think was sort of part of the thinking. And what they said is, we'll make an agreement with our employees that if you're an inventor on a patent, you get to have some say in who we sue offensively versus defensively. In other words, they made a commitment that they would only use their patents defensively, like someone else shoots first, right? It has to be on shooting them, not them shooting us on. And you actually retain permission. A lot of people, when they sign their patents to their employer, they never get to do anything with them. They don't have any control over them. Twitter says you keep control in theory, and even if we sell off the patents to someone else down the road, you still, your control over whether something is offensive or defensive, you get to keep it. So they try to give their employees some power in the situation. There's controversy as to how effective that's been. We can talk more about it later. I'll leave it at that. But that's basically, it's an employment agreement. This is a viral license. This is a kind of open source viral license. And I'll end there.
Thank you. So I think there are lots of questions as to that we can drill down into the details as to how this can work and what it looks like. But first, let's get through all these. So maybe Kevin, if you can talk about the license on transfer, a bit of a different technique.
Yeah, so I'm here to talk about the lot program, as we call it. This is the standard disclaimer. But basically, the lot, we sat down and started to look at a solution to the patent troll problem. And a lot of the academic research out there will show you, and it depends on different sources, but it's all pretty consistently showing that PAEs, patent trolls, NPEs, whatever you want to call them, are bringing a large percentage of the patent litigations that companies of all sizes face. And so depending on your numbers, it's 67%. I've seen other ones that are higher. And then we started to look at, when you have these suits going on, where are they getting these patents? And it turns out that majority of the patents, even from the PAEs, are coming from still operating companies, and it's more than 70%. And so this creates this sort of problem of that, well, these PAEs are bringing all these suits, and one of the ways that they bring the suits is they buy the patents for very cheap. And the amount of money that they spend relative to the cost of a total patent litigation, both even what the PAE spends in legal fees, plus with the defense costs, which are typically even higher. When you add all that up, the amount that the PAEs are paying for these patents is really a small fraction of that total cost. And really that's a real market inefficiency, because as much as there are a lot of lawyers in the room, it's not real efficient to be paying the lawyers to battle these things out when we could be resolving it perhaps through a simple licensing agreement. So the law attempts to provide a solution to that. A little bit more just graphically, what was on the previous slide, but showing you what the percentage of cases brought by PAs. Not only is it 67% as of 2013, I think it's even higher in the newer data, but it's grown over time. So the lot agreement takes a real simple idea, and as I said, it stands for license on transfer. And so the idea is we have, in this example, we have two companies. Obviously, we have as many as we can. They agree to join the lot agreement, and when you join, you make a commitment to everyone else in the group that says, if I sell a patent outside of this group, I will give everybody else in the group a license first. And so that ensures that once the patent is transferred out, that everybody who's in the group knows that they will never be sued on that patent. So even if a member of the group sells to a patent troll, you as a fellow member will know that you won't be a target of that lawsuit. And so as we have in the illustration here, we have two companies in, company 2 sells the patent to company 3, and at the time that the patent is transferred, this triggers a license to the other members. So it's a very, very simple idea that we were trying to starve off the supply of patents to the PAEs, and we've done this on an industry-led perspective. And so we have this was really started by some guys, Eric Schulman over at Google, and SAP was one of the founding members, along with Canon and some other companies, which I'll show you the list in just a second. But it's an idea that we could implement now as an industry, and it has appeal, we think, to both small companies and large companies. When I show you the list, you'll see we have companies that are small, less than 100 employees, to companies that are SAP or in Google size with thousands and thousands. We structured it to be a really low cost option. There's an administrative fee that we charge members, and it depends how the amount of your fee depends on how big a company you are based on your revenue. Even at the highest end, it's only $20,000 a year. At the lower end, it can be as low as $1,500 per year. And all the fees just go into helping administer this program. There's really no, it's not like Google is profiting from this or SAP is profiting from this. It's really set up to try and get a community-based effort to really restrict and cut off the supply of patents that go to NPEs, because the economics just really don't make sense for anyone involved. Just real quickly, sort of our status. We publicly launched in July, and we got picked up in a number of great press articles and things. We're really excited about that. To date, we have 16 member companies, and as you can see, some of the big ones include Canon, who's actually I think the number 2 or 3 patent holder in the world, Google, JP Morgan Chase, Red Hat, SAP, and then we also have some smaller companies, Khan Academy, GitHub, Pandora, Pure Storage. And so we have what we think is a model that works for everyone. And I think that's sort of borne out a little in you can see who our members are so far. And so in all, we currently have over 300,000 patent assets that are covered by the LOT program. So as members of this group, we know that whatever happens with these 300,000 patents, we're never going to be sued by an NPE on these. Now, one thing I didn't mention that the lot does create is it's really targeted at this troll problem. And so we only create this license if the patent is transferred outside the group. If SAP were to transfer a patent to Google, for example, since we're both members of the group, that actually doesn't trigger this license. And so if you are a patent holder and you need to sell patents or you want to spin out a business or something like that, you still have preserved the value of your patents because it doesn't trigger the license on that type of transfer. Similarly, if you were, I guess, similarly for small companies and large companies, they still see that value. If the patent is transferred outside the group, you would get the license. And then, of course, within the group, it actually is not a direct cross license. So if there is ever a dispute between two members of the group, you are still free to assert your patents against another member. The lot agreement in no way affects your own ability to use your patents as you would in any other way. That was really one of the key things, at least I can speak for SAP. One of our perspectives in joining is that because of the structure, it's really narrowly tailored to this patent troll or NPE problem. And you really don't lose any ability to do what you would want to do with your own patents. And so that was really important to us. Obviously, we're a large patent holder. The lot agreement doesn't really affect your ability to do cross licenses, for example, which is something that a lot of large companies will face. Or even working with smaller companies, we do cross licenses from time to time. But by preserving that, you're really preserving the value and really just only taking away this what we view as a really inefficient way of trying to monetize your patents. The others are just some more the pros and cons. The pros really, no cons here, I think.
None whatsoever.
Well, $1,500 a year if you're a small company. Yeah, I guess that. I mean, we have a small administrative fee. Like I said, that's really in our mind the only con. But we do have to keep the lights on. I guess that's all.
Okay. Thanks. So finally, before opening up for discussion, so Andrea was going to talk about the Open Invention Network, which is a defensive patent pool of sorts.
I'm Andrea Casillas. I'm actually director of a Linux Defenders program, which is separate from our licensing program at Open Invention Network, but I like talking about both. It's cool. And just as an aside before I start, I think it's, I started working with OIN nearly 3 years ago, and when I was talking about the various licensing aspects or just what I do, it was blank faces. So now it's great to see that there's so many options, and I think that the more options that we're presenting, it just helps bring awareness that there are alternatives to the traditional routes of protecting your IP and patents. So Open Invention Network, and then maybe it's just easier for me to explain how it began, but the easiest history story of it was about a decade ago. Your big software companies like IBM, Sony, Panasonic, I think you said you're on Panasonic, various others, they came together and they realized that patents and software can go several routes, and one of the routes can be really bad, and that's down this whole avenue where everyone's suing each other over trivial aspects of software, and those aspects that everyone needs in order to build and innovate and create new technology for software. So they came together and said, okay, basically, we recognize that this area of Linux is something that is really, really essential for us to work together on and collaborate, and it does no one any good to be suing based on this. Fine if we sue on anything else, but we think that this area, and we're going to just call it, to simplify it, the Linux system definition, is something that we should just create this safe zone around. So that's how it started 10 years ago, and it was much smaller than what it is now. Now Open Invention Network is one of the largest, or is the largest patent non-aggression community worldwide. And we just essentially have a simple mission to protect Linux and protect open source. So I'm going to, instead of getting into very detailed aspects, I think that's better for questions afterwards or during the panel. I'll just kind of give you a brief overview. And I'll focus more on licensing versus what I do on Linux Defenders, but I will do a little plug for Linux Defenders as well. But what we have is a community of licensees. And this number is actually a little bit dated. We're probably closer to 1,400 licensees. And they range from anyone from startups to corporations to nonprofits to individual developers. And they basically come together and agree to not sue each other. So it's a pledge of non-aggression. And in doing this, they get access to some patent pools. One is the Christ license pool that we have. And this pool is based on what the definition of the Linux system is. So a decade ago, this was a much narrow definition. Now it's grown, so it includes over 2,200 packages. But within the system, if your patents or your technology is within this Linux system definition, then it's automatically cross-licensed. And so right now, what it ends up being is over 1 million patents and patent applications worldwide that you have access to because you're a part of this community, the OIN community. We also have a second patent portfolio, and that's the OIN's patent portfolio. So just as we decide and we agree, it takes several intense meetings to figure out what this Linux system definition is going to be. There are other technologies that are not included within this definition. And so we want to make sure that if it's going to be something that's going to potentially threaten or damage open source development, that we want to try to get these patents and have them in our patent pool for our licensees, all of our members, to freely have license to. So we have over 1,000 patents and patent applications outside of the Linux definition that everyone, once you're a licensee in our community, have access to. And this is kind of just to illustrate what this Linux system definition is. I know that there's various degrees of experience within this area, but what we're trying to cover is this collaborative space. We want everyone to get to this competitive space, but the building blocks, we want to make sure that we're not suing based on those, because otherwise no one's going to get to this innovation area. And that's where you see the cool stuff, and that's where you see everyone taking software to places that we never thought it could go. So this is where we focus on for the Linux system definition. And then briefly, the other aspect, because in protecting Linux and open source, we do want to deter, and we do that with the license, but we also want to promote innovation. So we do this through the Linux Defenders program, and essentially one aspect that has been very near and dear to me is our defense of publications. And that, just as Jason mentioned how the open source community isn't patenting, we've recognized that that is an issue as well. And instead of maybe getting them to patent, we're trying to get them to write these defensive publications, which serve to be prior art to the examiner. Of course, the examiner in a perfect world would have access to all of this information, know where to find it, and have all the time to understand it. But it's not a perfect world, we get that. And so we're working on a way to distill it and actually capture everything in a repository that's easily digestible for the patent examiners, and helps protect the open source community at doing what they normally do, innovating, but writing a little synopsis, a disclosure, if you may, so that the patent examiner has this while they're reviewing the patent applications during prosecution. I think I can go on for days, but if you have any questions, I'm happy to answer them. It's a brief overview, but
Okay, thanks everyone for the overview. So as everyone was speaking, I had these, but Jason, but Kevin. So I'm going to ask my but Jason, but Kevin, but Andrea questions, and then I think we'll throw it open for questions. So my first question on DPL, but Jason, why have patents? How's this going to work? Why are companies going to go out and get patents if you're a DPL company and you can't use them? And if the whole concept is to, incent innovation and patents, how do these things fit together? Do they fit together? Do we care?
All right, so my somewhat cynical response to pieces, not the ones you are asking, but the
don't answer my
put out
question,
there,
just
right?
talk.
So I actually don't think patents incent much innovation at all. I think what they provide incentive for is certain investors want a backstop. They want to feel like you're a special little child, flower, whatever, and so patents are this symbol to them that you're special and that you're doing something different in the market. They're a way to signal in the market that you're different. I don't know that any startup and coder I've ever met has said, I wouldn't do that unless I get a patent, right? Like, I just haven't heard those words. So I'm gonna say that's probably not true for most people I've seen, and most of the studies, the empirical studies and surveys have shown that's not true. Now what is true is people don't wanna put a lot of effort into making something and have it just ripped off. That is true. But it's not necessarily that they are waiting for the patent, right? So there are other things you do in general to get those advantages, like being first to market, having technology that's hard to figure out, kind of collaborating or being part of a platform. There's all kinds of other things, right? And so one of the things we decided to do, though, was, this is a lot like law in some sense as well, and other things, which is you have a demarcation, right? So in the DPL, you don't actually commit to being defensive to everyone in the world. You only commit to being defensive as to other people who make the same commitment, which is sort of the open source community idea that a lot of these other, solutions or, agreements say, which is it's only a reciprocal agreement, right? So the people who agree not to sue me, I also agree not to sue them. Now let's say Microsoft never agrees to the DPL, we can all sue them, right? There's nothing that prevents you. You should go after them if you want, or if you don't, or do whatever you want. You can license for money, you can do whatever you want. So I will say that it does open up that option, but it creates a kind of community of people who want to work together to share and their patents in a defensive manner. Of course, if anyone ever sues you, you can fire back as much as you want. The other thing I'll say, though, is that patents cost money. Why would you spend this money? So this is a piece of what I didn't include there, which is there is a whole plan in place to make these patents low cost and or free for people. Free patents, come talk to me later. And then I'll just say, which is that we have some commitments from some people that if you are willing to commit to the DPL, like anything I patent, I'm willing to put it in this license. I run a clinic at NYU Law, and I have law students, one of whom is in the audience. And the possibilities of getting free legal help to get your patents for you exist, not just with law clinics, but with pro bono help from law firms, et cetera, et cetera. And I think that is something that can be handled. The other thing is there are foundations and other individuals who are also excited about this, and if it was the difference between you doing it and not doing it was the $6,000 of administrative fees at the patent office, that's also not a problem. So I think we're going to take away the financial burden of getting the patent. You have to pre-commit, like you have to be in. And then it wouldn't necessarily be every single patent. I don't know that we do all 50,000 for Bugzilla, but I think there would be some ways to get in the game and get things started. So anyway, that's our pitch, is that it makes it very easy to get patents if you pre-commit. And then you're in the situation, maybe like Twitter was, where you have 8 patents, right? Well, you have 8 patents. But then I have 15 patents and someone else has 25. Lots a lot like this, where suddenly you have 300,000 patents, right? And you think about this, maybe, Kevin, you might want to talk about this too. It's like, you start to think about this and you're like, okay, so how much would it cost my lawyer to go through 300,000 patents and tell me whether any of them are problematic? Right? How many thousands or millions of dollars would it cost for them to analyze all those patents and tell me if any of them are landmines I'm about to step on? Or I could just join the DPL and get them all for free. Right? So at some point,
you have such a scale.
And while you don't get them for free a lot, there's this sense that you get a layer of protection or an OIN. I think there's this sense that once the pool gets big enough, there'll be pure economic incentives to join just for some certainty or safety or security on various levels. And that's what we're also hoping happens too over time. Now we have, at this point, only 27 patents under the DPL. But again, like our goal is to grow it. we don't charge administrative fees. No, just like against Kevin and the lot, because I was actually on the lot advisory board, and I think it's a great thing. But I'm saying, like, we're trying to make it accessible.
Okay, I want to throw in some of the concerns that
Yeah.
So obviously with the DPL, scale matters. You know, if you only have 1 patent, 2 patents, 3 patents, I can see getting into it isn't scary. I mean, it's not as scary for me as maybe a Google or a Microsoft. You mentioned, you know, how do you get, how do you get the big players in there? I mean, one of the worst trolls out there right now bought a ginormous, 4,500 patents from Sony Ericsson. Like, Sony Ericsson probably wouldn't have been in there. So how do you? Like,
I mean,
Yeah, that's a big issue.
yeah, well, and maybe
and I guess lots of similar.
all three of us should talk about scaling, right? And I'll say from the DPL perspective, yeah, this is, you know, maybe I'm being idealistic and perhaps naive, maybe they go together. But you know, when some of the early pioneers of open source copyright licenses, Richard Stallman and some of the others, or even Larry Lessig when he was doing Creative Commons, was thinking about the idea that, you know, it wasn't about having Disney join, right, the Creative Commons network, right? It wasn't about necessarily having Microsoft or, you know, any of the other major software vendors of the time create Linux or GNU Linux or whatever, you know, piece of that, right? It was about building a community of people who believed in certain things, and then as you hope that as they get more successful and they start companies and those companies become huge. I mean, I hope all of you who are doing companies, your companies become gigantic, right? If you get in at the ground floor, my hope is that over time it happens. It may be a decade-long project from our perspective, or 2 decades, but I'm in.
No, it is interesting because it is a licensing mechanism. We think about it, and then we can sit here and ask, you know, about Jason questions, about Kevin questions, but it is also like a philosophy. It's a long-term thing that you're trying to build, and I think it's interesting that you noted that, you know, one of the things you see in terms of how valuable, I talked about, you know, just in traditional licensing, when you have scale, when you're able to aggregate patents, it's powerful. One of the reasons it's powerful is because no one's going to have time to sit around and go through them all. It's just too expensive, and there's some good stuff in there. And it's interesting that you're kind of turning that on its head if you can get to scale, you know, in this defensive sort of commons way.
So then the question goes, and then I open up my question to Kevin on, you know, so you mentioned that there is possibility of cross suit within the group. So if I pay my $1,500, that doesn't defend me against the 300,000.
Sure, it doesn't, like, sure, you could still have a suit between members. That was something that, you know, is specifically a design choice that was, you know, conscious. We're obviously aware of that. And we kind of view it as, you know, maybe the lot is the first toe in the water and DPL is maybe jumping in the pool. The kind of, you know, and so it's working in that direction towards sort of, you know, solutions to, you know, patent assertion problems. And we, you know, from our perspective, there are going to be a lot of companies who just aren't going to be comfortable with the idea of giving their direct competitor a full license to their portfolio, if that company's in the lot. And so the lot structure still preserves, you know, that if you have a direct competitor, it doesn't matter that they're in the lot. In fact, from our perspective, at least my personal perspective, I want my competitors in there because then I know that they can't engage in the dirty tactics, which would be selling off the trolls and privateering their patents out for me to be sued on. So that was something that, you know, we specifically, you know, were aware of. Obviously, it was a design choice, purposeful, in how it was implemented in that way. The other thing I would say just about, you know, scale and sort of the burden, if you will, of being in, is that with LOT in particular, and I think it's true with any sort of reciprocal agreement like the DPL, is that while yes, there is you're giving up something by being in, the amount that you give up is commensurate with how much you're getting back. As in, while the group is small, you're giving up relatively small amount because you're not, you know, if you were to sell a patent out, even when the group is small, yeah, you're going to give a license to a few companies, but you're not going to give a license to everyone, and that's fine. But then as the group gets bigger and you're getting more and more patents are being captured as more companies join, yes, there's a bigger burden if you were to sell a patent out, but at the same time, you're getting a lot more by those companies being in. So by having those sort of, if you will, the cost and the benefits sort of align, I think you get a really good solution because when you have these network effects that as it gets bigger, you're going to benefit more. It's going to be more cheaper. You know, everybody's going to win. But at the same time, even while it's small, you're not really losing anything. You're not giving up anymore while it's small.
Well, I mean, for LOT, and I guess, well, for anything for DPL and also for LOT, but I think any of these, I mean, is there an issue if you're a big company and you spent millions of dollars on research and you have 10,000 patents, like SAP or whatever the number was, is there kind of a free rider problem where you're saying, well, why am I giving this little guy? I'm getting one patent from you, and I'm giving you everything, right? If I thought about this back when I was at Panasonic, you have a long cross-license discussion, and you say, we cover your product, we have this many patents, our patents are good. I'm not just going to go in for free. You're going to pay me a lot of money because I spent a lot of money. So what happens to that calculus in this sort of open patent systems?
Actually, I was going to ask.
But,
Yeah,
Andrea, too, yeah.
Your stack diagram was kind of
Yeah.
So so for OIN, because it's centralized around basically a subject area,
Right,
let's
technology,
say.
yeah.
I think it kind of that issue. I mean, of course, we have the IBMs and we have the startups and we have various people that don't even, maybe they're going to patent something, but
Right.
probably not, because we work a lot in the open source community, and it's less about. I guess the monetary effects that you get, or what you get from the companies versus building that community and building the innovation. Because maybe it turns out that it's something that IBM ends up acquiring, or there's other kinds of value for the bigger companies that aren't necessarily apparent just by the cross-license.
Right, it's a shift. You're getting value in a different way because you're building something collaboratively. I like that. All right, so I have one more question, and then maybe we can throw it open to questions. But I mean, I think the question of commons, like efficiently using commons, and I think that's like a very law school. I remember that from law school, right? You have like a public space or a park. Like, how do you make sure it's like open for everyone, but people take care of it, and there are no free riders, and the people that are putting money into it are getting the benefit. I think it's kind of the same sort of problem here. Like, so you have this patent system where we're supposed to be incenting innovation, and maybe we are, maybe we're not. But a certain degree of that comes from competition and comes from giving someone a club, right, or rewarding them for disclosing their patent, giving them this monopoly, giving them the power to exclude. And so a lot of what we're saying is there a place for us to really sort of solve this commons problem and take this patent system that kind of gives a patent is really, it's a right to exclude, it's an enforcement club. And we're sitting here talking about singing Kumbaya and holding hands, and does it work? Does it fit together? I think it's a really interesting question, and I'm just curious where people see it going, and if those things work together.
So I as I said at the beginning, I'm excited about the direction that things are going, and I really think when you look at the technology companies out there, even the ones who aren't necessarily participating in these yet, they are starting to act with this behavior, with more of the defensive mentality. When you look out there, you don't really see the Googles and the Facebooks suing each other offensively. Companies, Dropbox, Dropbox obviously part of the law, but I get the sense, that at least even in the companies I've represented as outside counsel and at Foursquare, like this is the general push. The general push is, hey, we're not trying to just profit off each other. We want to innovate. We want to come up with great things. We don't want to be ripped off, but we're not just maliciously going out there to stop. And so I do think we are at a time in the world that we're more open to this. I think this discussion will continue. I think there's other ideas out there as well. Google's got a few as well. This is a good time for us.
Yeah, no, it's kind of cool because I mean, a lot of I think where I started with that history is the industry has developed into a way to sort of use patents to make money, sort of separate and apart from products. And I guess what I'm hearing is let's just make cool products. Yeah, that's good.
Well, so a couple things. The commons issue is kind of interesting because so in economics and in law they talk about these old English commons, and people would bring their sheep to graze, and if you bring too many sheep and everyone brings their sheep, then there's nothing left. Turns out that actually wasn't what happened. That actually people took very good care of the commons. So there's a sort of myth of the tragedy of the commons. It's actually not true. It was actually just fine. People really cared about these central spaces. So this idea that economists put out there, like many ideas that economists put out, was actually not true in reality. But anyway, putting that aside, one of the things about ideas and intellectual property is it's what economists and lawyers call non-rivalrous. I mean, lots of people can use things at the same time, and they're not scarce resources. Like if I have a chair, like we just had here, and somebody sits in it, I can't sit in it. That's a rivalrous thing. We're rivals for it, right? intellectual property, everyone can take a license. Doesn't mean that the next person can't take a license, right? So we have a kind of different economics when it comes to ideas and intellectual property. I'll say this though, one of the other things about this is the reality of patents, and this is actually the reality of most of intellectual property, is that you're talking about kind of like who's suing who and whether they're defensive. To actually sit down, like say I'm a startup and I have a patent and Google and just blatantly steals my technology. They find the code, they put it in their thing. It happens sometimes, right? I'm not saying Google's any different from any other company. How much is it going to cost me to actually enforce that by hiring lawyers and going to court and going through a whole long trial? It's going to cost me
A lot.
Yeah, I mean, but again, Brian, how much would it cost if you had a patent and a big company were infringing it? How much do you think you'd pay outside lawyers to get all the way through trial and appeal?
All the way through trial?
Yeah.
You're looking at, if it's a small case, you're looking 700, 800,000. You're looking more up to like 2, 3, 4 million.
Yeah. So that's a lot of money. Now maybe it's worth it. Maybe it's a $500 million patent or something, and you're great. But the chances of it actually being something that's economic for you to do isn't that common, right? So the other thing I say to people is, like at startups, is think about where you want to spend your money too, right? The thing that we're asking, and to some degree all of our our kind of schemes, if you want to call them that, are asking, is primarily to be defensive, right? And to spend your money on engineers and marketing and getting out there and connecting with your customers, not on lawyers, right? This is a don't spend money on lawyers plug. Sorry to my students in the audience. But,
Whoops.
But no, I mean, so there's a sort of philosophy there.
You can always
as
be
well,
corporate
right?
lawyers.
Is to say that spend money on engineers and making shit, don't spend it on suing people unless they sue first, and then there's a kind of detente kind of philosophy to negating that. So anyway, so I think part of this is also that shift that a lot of companies, big and small, now realize that kind of offensive shakedown move works occasionally. There are examples of making a lot of money, but it's not the common approach. So I would say that's also sort of part of the shift that Brian's talking about.
Great. Yeah, so that's exactly why I'm shifting out of law and into moderating full time. So see you guys next week.
Sports writing.
And also writing a little bit, yeah. So questions from out there? Yes.
So if I am an early stage startup with no investment and I'm trying to decide whether to join the DPL or join the lot, am I going to scare off investors if I commit my patents that don't exist yet to the DPL? And how do I comfort them? And with regard to the lot, is it worth my investing $1,500 I haven't raised yet to join now?
It depends on which investors. So there are, I mean, we have several investors, obviously, and we have some that are very pro DPL, IPA. So a lot of, at least in the tech sector, they understand this concern, and so you're not going to freak them out. I don't know if you have no investment yet, you have no patent and no patent application. I probably wouldn't advise just jumping right into the DPL at that point. You can always jump into it in 6 months.
What if we're activists?
If you're activist, well, I'm just thinking, until you have, the trolls come when TechCrunch posts the article that says such and such company raised this much money, because the troll says, okay, you raised $2 million. The troll says, okay, I want 10% of that.
Yep.
So until you actually have raised the money, you're not going to get the benefits necessarily of the.
Yeah. I would second that.
I just have a question. Is the value, from your perspective working with these investors, is the value diminished at all by having any kind of, because I've always said, no, it's great, because that's what I think, and that's what we propose.
Yeah,
But
and just to add to that, just because one thing that I've seen, so there's some companies that were startup companies that I worked with when I was in like a clinic at law school who had great technologies, who had patents, who ended up not working out in the marketplace. And I think their investors took comfort in the fact that, hey, it was a hedge, as someone said earlier. Hey, there are these patents, and the patents actually were monetizable, and there were assets. So, I mean, how does that play out?
yes.
Actually, no, they were eventually defensively aggregated, but they probably would have. But I mean, that's the question, right? For them, it's a value. So, I mean, how does that play out?
Well, so there's sort of three answers, I think, from the DPL perspective. One is this is exactly the conversation we had 30 years ago about copyright and open source licensing. People saying you're insane. How are you going to get people to pay for this if you give away your source code for free, right? So I think we're at sort of a similar place where maybe investors,
There's no way to hit that conversation.
and, I understand why they come from this perspective sometimes, and there are investors who are very, I think, progressive about this. Some with offices very near this building, but very near, yeah, very near this building, and also in Boulder, Colorado, and in San Francisco, and a bunch of other places. So one thing might be that we might get to a point where certain investors who think of this as a good idea might be more interested in you if you actually think that. But the other thing is, and this is part of it, like, I haven't dumbed this down to the kind of 30-second soundbite, and if you have an idea how to do it, I'd love your help, because I do think investors kind of go on the, what's the pitch, right? And I think part of it is, like, if you're a startup and you're just getting out the door, access to a lot of these protections might actually be the thing you need when TechCrunch says you get your first $2 million investment. Like, it's more about being part of defensive mechanisms that will help keep you safe, not the one patent you think you're going to sue someone on, right? And so it might be more that it depends on your business strategy to some degree, but you might be pitching that the reason I joined these agreements. By the way, I think you can join all of us, including adopting the IPA without conflicting. Like, it's not like a one or, it's a one and if you want. But that might be something you pitch them as part of our play is to be part of these defensive networks, sort of have some protection as we enter the market, both from trolls and maybe from other people, depending on which thing you join. But the other thing you have to think about, and this is the part where I think it requires logic, and I don't know that investors always apply logic, but so say you join the DPL and some giant competitor also joins the DPL. You get access to their patents for free, forever, as long as you don't offensively sue them. In other words, if Google were to join, or SAP or anyone else were to join the DPL, to get access to your 8 patents, you get access to their hundreds of thousands or whatever, right? So you suddenly get to use all that technology without worrying about them suing you as long as you don't sue first. So there's a kind of economic strategic advantage. Now, DPL has to be huge. RE is pretty big. OAN actually has a lot. So we have to grow these networks, but there's a business case to be made too, I think, as to a startup getting a lot of security and safety from potential outside threats. The lot model, just to pitch it for a second, is to say, look, if I join the lot network now, it means that if they ever sell off to trolls, I'm okay, right? When you make your $2 million investment, it means none of those patents will come back to bite me. That's why I'm joining the lot network.
Just to sort of on your question of the timing of when you would do this in your stage of development, whatever it says, that's what right. The trolls, the first thing they do is once they hear of funding or they hear a product that becomes starts getting some press and becomes a hot an up and coming kind of product or project or piece of software, what have you. That's when they start looking because the trolls absolutely they chase the money, right? That is part of the idea is that they're going to go wherever they think that there's an ability to extract a settlement or to even try to take a case further along. One of the things that I guess you're sort of the way what you're trying to weigh, I guess, a little bit aside from perhaps a little fee is going to be the all right, well, you mentioned that okay, his company failed, he had some patents, they sold them out to somebody. Well, does that hurt me if I join the lot in the long run? And I would say, the simple answer to be most direct about it is, if you're optimizing your company for bankruptcy, you should not join the lot. If that's what you're worried about, then yeah, you probably shouldn't join the lot. I'll give you that. But like I said, it's
you probably shouldn't mention that in your pitch.
Right, but for companies,
Save that for the backup slides. The backup slides. Yeah.
Smoke coming out of a hole in the ground.
So yeah, if you're trying, look, if you're optimistic about your future, you plan on making products. I think everybody who makes products will tell you that's what they care about, and it's the things that inhibit them from making the product is what they're really scared about, and that's what a lot tries to tackle.
Great. Okay. Other questions? Yeah.
Yeah, so I'm a lawyer, so I'm asking
I'm sorry.
question.
Me
so
too.
I've done work in the firm setting, also now do a lot of work with startup clients. This is maybe a theoretical, but it is a practical legal question as well. So my understanding is if you join these networks, everyone sort of has some interest in your patent ownership, right? That potentially makes them an interested party in the litigation. So I'm wondering, supposing somebody outside the network sues somebody in the network, who's the client? Is everybody the client, or who's the lawyer? What happens in this area?
Nobody's an interested party in the DPL except the parties to the license. In other words, it's a what they call a bilateral license between A and B.
Yeah.
Now it's a network of these licenses, so it looks like a spider web, but it's really each. You have to accept the license from each individual person and the mechanisms for doing
So
that.
it's not an automatic sharing.
I don't know about the others, but we set it up that way.
Yeah, a lot is an individual license between companies. It's actually, we're gonna get to the legal part that's, the
Yeah.
details of it. I mean, it's in the agreement and we have like some explanatory materials that go into a little bit more detail, but it's actually structured as, it's a license to everyone that only becomes effective upon the transfer, or the triggering event as it's defined in the agreement. And so that's actually done, I don't know how you guys ever handle this in detail, but there's some provisions in bankruptcy that you actually worry about that if a license doesn't exist, it can't spring in after they file for bankruptcy. So the way the law has been structured is actually it's a present license, if you will, with all the members, between each of the members, and but the effectiveness of the license doesn't occur until there's the transfer or the triggering event. And so that's I think purely like a legal structure to comply with, sort of the way, yeah, the way the law's done. But conceptually, obviously that's the transfer point is
Um,
Yeah, so the party in interest, we've had individual members sued, and that doesn't trigger the entire network.
Case capture would be crazy.
Yeah. That would be a very busy day at the Dawn. But I think I thought you were actually getting to, because I was thinking about unified patents and how that's a question with the re-examinations.
Sure. I was actually going to follow up with that
Okay.
question, which is if everyone sort of has, or many people have interest in a patent, who handles renewals, re-exams, who handles administrative?
So you're not going to have standing with the U.S. patent offices and non-exclusive licensing. It's the bundles of right question. So you're not going to be able to just.
So it's the owner.
Yeah,
Yeah.
It's the
the
owner.
owner is
It's the
going to
owner.
be the only one who can do that.
Other questions? How are we on time, Eric? A couple more questions, or
24?
maybe one or two more questions? Yeah. Sorry. Oh, go ahead.
You're all coming from the perspective of tech, or the sort of computer-based technology. How do you think this is different from biotech or agriculture, for all these other industries that do have innovation, but not probably in the same pace? They don't patent as much necessarily, but they spend an awful lot of money on their research.
Yeah, that's an interesting question, just because industries look at patents in different ways, right? Consumer electronics product companies, for example, there's a lot of patents. You need a license to a lot of patents to make something like a smartphone, whereas a drug company may need one patent on their drug. So how do you guys feel about that? Or Andrea?
So, since our definition is based on software only, we kind of, the other areas, pharma or everything else, we don't deal with. But that said, software is pretty prevalent in everything. So, we're not closed off to other kinds of industries, depending on how that sits with our definition of Linux.
But do you think there is an advantage to other technologies to actually think about these kinds of processes?
Well, Tesla, their patents are with respect to battery technology. So, they are trying one model.
There are open innovation movements in agriculture and citizen science and pharma and lots of other areas. I think they've focused more on kind of access for poor populations or other things. And what's been interesting is that a lot of the companies, because of the political pressure, have tried to work out, not all of them, but some of them. Also, in other countries, they have better laws. So in India, for instance, you can challenge a lot of pharmaceutical patents because they don't actually have any therapeutic effect. So they don't actually make you any healthier. Here in this country, you can get a patent on something that has no medical effect, therapeutic effect whatsoever. So anyway, I think that the politics and economics can be different. I will say, though, that at least with the DPL, we made it so it would work with any technology. So if it's appropriate for an industry, then they can use it. If it's not, that's fine.
Maybe one more question? Yeah.
So it seems like there's actually a lot of like similarities between like all the different ideas and even the entertainment business as far as like Netflix and Redbox, and you have all these different media companies that are licensing content. And you know, they're afraid of one company to kind of get too big and have too big of a portfolio of media and TV shows and movies, so that because they would then have like all the power. What's this? My question is kind of what controls the direction of the actual, I guess like for instance, who's controlling like the decisions that Lot makes as like a company or PL? And then say like, I'm not happy with the direction of that. Can I withdraw my patents from the portfolio? Is it similar to like a cell phone contract where I'm committing to life? And then I have to
Your minutes don't carry over.
termination fee?
Ridiculous. Yeah, I'll let Kevin take that.
Yeah, just for a lot, I mean, you're committing the patents that you have while you're a member for the life of those patents. If you decide, so I should say also, for the lot, it's not really going to change. The agreements, and I forgot to mention it, and I'm probably going to get in trouble with the guys over at Lot, but it's lotnet.com. It's an open agreement. You can read it. It's posted there. The list of our members is there. Everything is open about it, and so it's fully transparent. If you do join, while you are in, and this is all explained in more detail on the website, while you're in, the patents that you have at the time while you're a member will are subject to the triggering obligation for the life of those patents. If you decide I don't want to be in anymore, you can do that and you can leave, but then only the patents that you acquire after that date, after you leave, would be free of the lot obligation. So now at the same time, if you leave, you also won't get new licenses that trigger after you leave. So if you're a member today, but you quit tomorrow, and then Google sells a patent the next day, you wouldn't get a license to that patent. So you only get the licenses while you're a member.
So is there, and then as far as like the actual company structure of like LotNet, or and the other ones too, I'm interested in. Is it that the members technically, I mean, in a way have shares, not really, but who votes the change and the direction of the overall company?
Yeah, I think we are technically a mutual benefit corporation, I think is what Lot is. So we have a board of directors, which I'm on the Lot board. We don't get paid anything or anything like that. It's just, it's sort of it's just helping the organization, and really just establishing the agreement. We worked a long time, a lot of lawyer hours went into this agreement to get it, the goal was to get it right the first time, and I think we've done a really great job on that. So really, once it's sort of set up, there isn't a whole lot of changes that you can expect. There's voting rights and things like that. If there were to be a change, there's an amendment process. There's it's a percentage of members all have to agree, and if you decide that you don't like one of the changes, there are actually ways that you can limit and say, look, I don't like the changes you're proposing. I want to stay under the old agreement, and you can stay in under the old agreement. You just don't get any sort of differences that come after that wouldn't apply to you.
Are the others fairly similar in that? Just in overall?
Oh yeah, to say, so we're similar in the sense that there's a way that you can get out. You have to give a 6-month notice that the new patent you get after 6 months won't be under the DPL. But I should say, the DPL is essentially me and another professor and a couple other people. We don't own any of the patents. So what we're doing is promoting an idea, much like Creative Commons or through Software Foundation or some of the other things about promoting this license as an idea. The people who own the patents are the people who own the patents, and the people who license them, and that's all up to them. We have a website where we try and list all the patents that we know of that are under the license, but we don't have any control over what people do.
Andrea?
Yeah, so our termination is similar as stated. We do have a board of directors that are made up of our investing members, so that's Google, IBM, Red Hat, NEC, Panasonic, and Sony. So those members are still part of our board, and some of them are active as far as being on the tech committee, which decides the definition of what Linux is. We also have a lot of tech committee members from the open source community, Linux Foundation, and the various communities within that to help kind of decide what that definition is and steer how that grows throughout the years.
Okay, so
I'll just throw on the Twitter IPA is one example where that's Twitter's agreement. Twitter has shared it with others, and they can use it as they wish, and they can amend it, and they can change it. And so that, I mean, that's one where it would be company dependent, not necessarily.
So I think it's fitting that we ended up with termination and how do we get out of these things. So I think that's a wrap. Hopefully this was interesting and fun, and one day there will be profit too, I guess. So thanks everyone for coming. Thanks to the panel. Thanks, Eric.